everybody. Welcome. Good to see you all here today. Thanks for joining me. I'm gonna wait a couple minutes. Give everybody a chance to get settled in and start typing your questions. We'll be providing instructions in just a minute, but if you have any questions, you're welcome to start sharing them in the Q&A panel now as an anonymous attendee. Give it just a few minutes for everybody. We'll get started. And actually, okay. Hi, everybody. It's so nice to have you here today. This is an Ask Me Anything on immigration. My name is Sophie Alcorn. I am the founder of Alcorn Immigration Law, the host of the Sophie Alcorn podcast. I like meditating. I'm a mom, and I believe that the world should be a place where every child has the opportunity to live their dreams and self-actualize and get into their flow state. And that when every human gets to do that, when barriers to that are removed, then the world will be an amazing place. And you're welcome to reach out to me. I'm at sophie@alcorn.law. And I'll turn it over to my colleague, Rebecca, to just share some important announcements before we get started on the Ask Me Anything.
Thank you, Sophie. Good afternoon, everyone. Thank you all for joining us today. I have a few housekeeping items before we get started. This webinar is being recorded and the recording link will be made available to you. This presentation is an educational service by Alcorn Immigration Law, and the information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. Lastly, please submit any questions you may have by using Zoom's Q&A function and do so anonymously. These questions are shared publicly, so please do not share any sensitive or personal information. It's now my pleasure to introduce you again to our founder and CEO, Sophie Alcorn.
Thank you, Rebecca. Thank you so much. Hi, everybody. I also want to introduce you to our amazing team at Alcorn Immigration Law. We're growing and we're going to have a couple new attorneys be joining us very soon, as well as paralegals. So we're very excited about that. But we're a remote, decentralized team, and we help people from all over the world get visas and green cards to come live and work legally in any part of the United States. We're not doing the hand raising, or you can if you can find that functionality. But you're welcome to put in the chat window or give me a thumbs up or something if you can. But I think a lot of people are drawn to U.S. immigration and might have questions. You might be here on a visa. You might want to personally immigrate. You might be looking at sponsoring immigration for a team member or even a family member. Maybe you're at a startup or you're wishing you could have a startup one day. So I have several slides that I can go through that might help jog your memory on what questions you might have, kind of to give you the lay of the land as an overview. And we'll be going through what some of the questions are already asking about. So thank you for putting these in the Q&A panel. How do we upgrade to EB1A? How do we move forward in AI and software engineering as a new grad? So I'm very happy to answer those questions and more. And we have an intimate group today. So if you have questions, I should have time to answer all of them. So please ask them early. And maybe I can even get you out of here with all of your questions answered early, although I do have the full hour if anybody needs it. So let me just start with some immigration context because I feel like this really sets the stage for people. and helps just put everything into context. Um, so, there's a lot of reasons why people are interested in immigration, especially when it comes to the tech field and startups and folks in the venture ecosystem and rapidly scaling technologies, both hardware, software, AI, robotics, biotech, and life sciences. All sorts of industries are really growing, and they are attracting the world's best and brightest people who want to be able to have a secure future in the United States. So there's so many motivations that different folks have. It can be about launching new technologies, driving profit, and having that hockey stick growth curve of your startup, rapidly launching and iterating, working with the best minds, recruiting the best people to come join you, getting money in order to blitz scale, launching your career. And also, just at the end of the day, establishing that home and creating the secure foundation for yourself and maybe your family that you already have, or the family that you might want to start one day. So, super personal in so many ways for everybody, even if you're going through and using business immigration routes to achieve what you want. Um, so I get that. And that's one of the reasons I decided to start Alcorn Immigration Law, was to work with people directly who wanted to be able to change their lives and do some work of meaning and impact in the world. So today I'm so happy to answer all of your questions. I see a few more coming in about opportunities for being able to work in multiple roles at different times in your visa or green card journey, and then trying to figure out the best and fastest options for visas and green cards depending on your plans. So we can cover all of that: visas, green cards, founder relocation, sponsoring family, sponsoring your team. Happy to chat with you about all of that. So I think what I'll do is I'll go through my slides pretty quickly. And then as I go through, I'll pause and I'll focus more on the relevant slides that relate to your questions that I'm already seeing. And then I'll also reserve time at the end for more questions. And the first question I can answer is, will this recording be shared later? And yes, it will be. You'll be receiving a link to listen to this in the next few days from Rebecca, who will be emailing that to you. All right. So, okay. So first of all, the typical path, most people are in the United States on a visa, like an F1 or an H1B, to go to school or work for a company. And then there's some sort of new career opportunity that's interesting to them, or they just realize they want to stay in the US as their permanent home. So they're interested in either changing jobs and getting the right visa to allow them the work flexibility that they need, or pursuing a green card to be able to have that long-term security in the United States. I will just point out that if you're not currently inside the United States and you don't want to move here immediately, but you would like to have a green card, it is possible to apply for a green card from another country. You do not need to be in the US already, but most of my clients have an immediate financial opportunity that will bring them here in the short term. So they do want to figure out the right visa while they're waiting for the green card process, which could take 2 to 5 to 10 plus years to go through, depending on which category you're in. Okay. So there's a lot of options. It's kind of an alphabet soup, but I know that we already have some O1 questions. So that'll be a good place to start, especially because it is such a valuable option for startup founders right now, and also creative people working in small businesses. The O1 can be very, very beneficial. It is for extraordinary ability. You can get it as an engineer, as a scientist, as a business leader, as a founder. There's many, you can get it as a UX UI designer or another type of creative person, for an O1B for artists. you need a job offer, or you can have an agent petition you. If you have an agent petition you, you can actually have more than one job at a time, and you can change jobs without necessarily needing an amendment. So that's a really great thing. So many of my clients who need to change jobs or be self-employed in the next like 3 to 6 months end up pursuing an O visa. The only major group of people who don't want to get an O1, even if they're qualified, would be people on H-1B whose spouses have H-4 work permits and their spouse has a job. And so their spouse needs access to that work permit to keep their job. So the main immigrant spouse can't switch away from H-1B to O1. All right. Just scanning through the questions. Oh, I love all the questions. Okay, this is great. Okay, so O1 agents, let's look at that. Okay, so for O1s, the basic eligibility criteria for an O1 visa for extraordinary ability in business or the sciences or engineering, so like startup founders, you need 3 out of these 8 categories to qualify. And what the evidence looks like for an academic researcher at a university is going to be very different from what the evidence would look like for a startup founder. And that's okay. There's no hard requirements about which evidence can be used for which category. So it really comes down to the strength of how your petition is written and argued based on your individual circumstances. So we always do a consultation with our own independent analysis, initially verbally and through a questionnaire and discussion, but then also we have our legal launch program where you can follow up for a 4-week evidence assessment program where we give you our checklists and you upload all of your evidence of your past accomplishments, and we do a 3-stage internal review and give you recommendation. Either, yeah, you're qualified, let's credit the legal launch fee to your case and get started immediately, or hey, look, we feel your case would be stronger and more approvable if you completed XYZ evidence within the next 6 months. So please go ahead and do that. But we can mix and match all of these categories in different ways. And at Alcorn, we've helped people across a variety of job types. So founders, researchers, engineers, TikTok influencers, inventors, investors. We've got no ones for VCs even. So it can be a wide range of occupations that you want to do in the future. And, many of our clients have awards, but that's not relevant for everybody. And some of our clients might judge competitions or hackathons or review papers, but not everybody does that. So you just need 3 out of the 8 criteria. And then, we can establish if that's sufficient weight of the evidence for us to be able to proceed. Okay, so we did have a question about the O1 with an agent. So I'm happy to answer that one right now. Can you get an O1 and then start looking for jobs if it is petitioned by an agent? And then we also got the question, can you talk about the O1 agent? How does the agent work? And then we have another question that we'll also get to in our green card section about how do you go from O1 to a green card? So, okay, so the O1, you cannot self-petition. Somebody else has to literally sign the I-129 form, which is the petition for extraordinary ability. And the law says that that can either be somebody representing a business, which is offering you a job, part-time or full-time as an employee, or it can be an agent defined as basically a professional who works in your field who can vouch for the fact that you have real work lined up for you. So the agent concept originally started with actors and musicians in Hollywood who would have like a music agent and or like a movie star who would have an agent and they needed to come to Hollywood and film movies and then film TV commercials, and then they would like take a break and sit on the beach, and then they would, go get paid to give a speech, and then they would get donations for their charity, and then they would go, film a photo shoot for an ad campaign. So they had all of this intermittent contract work where they were getting paid directly, or their agent would get paid and the agent would give them a cut. But anyway, variety of paid work in different types of agreements, which could be at will employment, like a typical salaried or hourly worker at a company, or like as an independent contractor, like 1099 with contracts. So at Alcorn, what I started experimenting with 3 years ago with a select number of consenting clients who wanted to do this was try to copy and paste that model from the entertainment industry to the tech industry. And what we've been able to establish is that using an agent is a very effective way for a person in the technology field to get an O1 approval that allows them to have multiple employers, multiple projects, a job and a startup and being a paid advisor and receiving equity in somebody else's startup, getting book revenue from sales of their book. There's a lot of things, a lot of income earning opportunities that my clients have that are not strictly limited to like a 9-to-5 W-2 job. And so the O1 with an agent has been a wonderful way for them to achieve that. The agent can either be a colleague in your field who you trust, who's not necessarily making any money, but they're willing to sign your paperwork and get you a return ticket home if there's no further work for you to do in the US and you have to leave and you don't have any money to buy your own ticket. They would be on the hook for buying your return ticket. A lot of our clients prefer to just keep professional and personal boundaries. And so there's a variety of professional agents you can use, and it seems that our clients have been having success with one particular agency. We don't make any money from them, but they have charged our clients $1,000 to be the agent of their O1 petition, and there's no like income sharing or anything. There's no revenue sharing from our clients' work. It's just a flat fee of $1,000 per O1 petition. So that's been an effective way to get O1s approved for our clients now over the years in software. So can you get an O1 and then start looking for jobs if it is petitioned by an agent? Yes and no. You need some initial work to get the original O1 approved. Usually that's a job offer or multiple job offers or an itinerary of services or, attending conferences, giving speeches, doing consulting work. We have to be able to show that there's a purpose for you to be in the US for up to 3 years when we're applying for the O1. But the way I have structured the O1s to help my clients have the most freedom within those 3 years and not to require constant O1 amendments every time a project changes. Our practice is to craft them broadly so that we get pre-approval for new projects as well. So from that perspective, if you wanted to start looking for additional work once you have that 3-year approval with the agent, you could, assuming the work still matches your field of extraordinary ability. So that's how the O1 works and the agent works. And another question about that is, can you be paid on a W-2 if you go via the agent route? Yeah, that's an excellent question. And it's related to the next question. Can you work full-time at a software company and also have a startup if you go the O1 route? So I think there's 2 separate factors. One is what human resources at a company will allow you to do. And the other is the intellectual property considerations. So so the I-9 employer handbook that talks about which documents are valid proof of identity and ability to work when you're onboarding at a new company for the I-9 form. That handbook states that an I-797 approval notice can be sufficient evidence of somebody's ability to work in the United States. And with an O1 with an agent, you do get an I-797 approval notice evidencing your ability to work. Now, depending on what we put in the petition, that I-797 might be tied to one employer, or with an agent, it could be tied to one gig, or with an agent, it could be tied to an itinerary of services with a lot of gigs and the potential for new gigs. So in my experience, if you work at a big tech company or like a bank, their HR is going to be very conservative, and they might not be so excited about A, petitioning you for an O1, or B, hiring you on an O1 sponsored by an agent. However, a lot of their reluctance comes from conservative immigration attorneys at the law firms that they work with, that I think at Alcorn, we're very much on the leading edge of trying to create new solutions for people. So a lot of this is like very, very new. They might not want to hire somebody on an O1 with an agent, or they might be suspicious if you say that you just did your own change of status to an O1 with an agent, and hey, it includes their company with your offer on their itinerary. And so you're still going to work here, but you just wanted to update your I-9. But in that scenario, you could be like, oh, you don't like the fact that I have an agent? Well, then I need you to please petition me for an O1 so I can work directly for you. And the proof that I qualify for an O1 is that I already got an O1. And then theoretically, if you had a side gig that they would not include because now you're not using an agent and you're using a single employer, you could always get a concurrent O1 for a second set of services, and that could be petitioned for by an agent. So there's a lot of ways to navigate that, but I think the important thing is just getting an initial O1 approved, because then it's clear that you're qualified, right? So then you have that like more negotiating power in your favor. You can be paid, so you can be paid on a W-2 if you go via the agent route, if the employer is willing to employ you. And big tech companies are more conservative, and you might have more issues doing it with them. But small companies, startups, they're usually very comfortable with this and just excited that they don't have to deal with your immigration. So it just depends. And then the next question was, so you can work full-time at a software company and also have a startup if you go the O1 route. So yeah, theoretically, you could have like 15 different things that make money that you do that are in your field on an O1 with an agent. But now the thing I want to caution you about is, and I did a webinar on this with an IP attorney named Sanjay Prasad, and Rebecca, maybe you can find the podcast recording link to the Sanjay IP podcast and share it in the chat window for us. But anyway, if an American person with a passport wanted to start a tech startup that was likely to be worth $1 billion or more, and they were working at a big tech company, they would probably quit and go on a 6-month sabbatical. And then you hear stories about how people like magically coded something over the weekend and it became an overnight success after they launched it on Monday. So there's a really big gap between when they quit the tech company and when they launched their new project. And they never in any cases would use the tech company's Wi-Fi or company laptop or company time to have built anything related to this new technology. And that is how they establish clear ownership over the intellectual property of what they created. Now, if you're on an H-1B, for example, you don't have that total luxury of time and freedom. So what many of my clients do, if they have like an idea or somebody offers them a letter of intent, or some investor is like, hey, I believe in you, if you build X, I'll give you Y amount of money, they would make plans to figure out their company and their immigration, but without authorization. And then there's a very tight sequence of events that we can personally walk you through that relate to the appropriate time to give notice at your company and when to incorporate and when to quit and when to be in your grace period and when to file the new documents for the new startup. So to answer the question, so you can work full time at a software company and also have a startup if you go the O1 route. Yes, theoretically, but also if your software company employer might lay claim to the intellectual property related to your future startup, then having an O1 that allows you to work those two jobs might not be worth it. So just proceed cautiously. And I'm not an intellectual property attorney. I'm not an employment attorney. I really just know immigration law and then what I see people do based on their lawyers in these other fields. Okay. Would big tech be more favorable to a concurrent H-1B cap exempt H-1B than the O-1 with an agent? Maybe. I think all these nuances really depend on your end goals and your family needs and your travel needs and your current immigration situation. Maybe. I just don't know. But see, a lot of big tech companies aren't sponsoring like they're not finding you the cap exempt part-time work directly. So, that could have its own issues. Okay. So let's keep moving ahead. We've talked about the O1 and agents. I do want to mention that for people from certain countries, not India, not China, not Russia, not Brazil, but many other countries have E1 and E2 trade and investment visas. So like if you're from the UK and you want to invest $100,000 of your own money into your tech startup, but you don't want to raise VC funding and you think you can just bootstrap and you want to create jobs in the US, like maybe the E2 investor visas for you. Or if you're, a German company and you've hit product market fit in Germany and now you're in a US accelerator and you want to find product market channel fit in the US for your US market expansion, maybe this would be a good visa for you. But you have to maintain at least 50% ownership by people or companies in or of your foreign country to be able to qualify. So if you dilute by raising subsequent rounds of funding in the US and then your startup is less than 50% owned by citizens or nationals of your country of citizenship, you may render your team ineligible for these e-visas. So that's something to be mindful of as well. And I did see a question related to this. So I'm just going to see if I got that answered. Okay, so somebody had asked if you found a company, how long do you have to wait to bring it to the US, or can you instead directly found it in the USA as someone who is not currently in the US nor has any visa? So what a lot of startup founders do, because US investors want to invest in Delaware C corporations, is they use an online program such as Clerky or Stripe Atlas to incorporate. And then if you use Stripe Atlas, you can start a Mercury bank account, even if you're abroad. So then you have a US company with a US bank account. It can own your IP. And then if you need to hire people in your home country, you could create a subsidiary there and transfer money from the US revenue to the subsidiary. And then that would set you up to be able to transfer people to the US on L visas, which we'll talk about in a minute, or for you to potentially get an E1 or E2 trade or investor visa after you've put enough money into that Delaware corporation. And investors also like it because usually for safe notes, and then whether it's pre-seed or seed or angel round, if you know you want US investors for Series A or B, and you are starting now with a clean slate, then it might just be the most prudent and simple and easy thing to do to start with that Delaware C corporation and register it to do business wherever you want to end up moving, like California or New York or Texas or wherever you want to head, and set up the company structure that way, starting with the end in mind. For the E1, substantial trade can either be based on dollars or number of units or number of orders or number of customers or number of transactions. It's very flexible, but we have to show like an ongoing pattern of trade between the two countries in the past, not just like projected future predictions. So usually, like if you've been selling software from Australia to the US for the last 2 years and all your customers are in the US and all your engineers are in Australia, maybe something like that could work. Okay. So next up, we're going to talk about the L1, and we do have some L questions. So the L1 is a visa for intra-company transferees. So if you work at Google and you don't get accepted in the H-1B lottery after enough tries, they're probably going to move you to Google Canada or Google Switzerland or something. You work there for a year as a manager or executive or a person with specialized knowledge, and then they can try to transfer you back to New York or Mountain View on an L1A visa for a manager or executive, or an L1B visa for specialized knowledge. Now, brand new companies can also qualify for the L1, even if they just opened up their US entity, like a Delaware C corporation registered in California or a California LLC, you know, depending on if you're going to raise venture funding here versus if you're just doing sales and marketing for an established overseas corporation and all you need is to get some salespeople in the US, but you're not raising money here. It's kind of a different corporate structure. So for a new company, we would have to show that the person has had at least 1 year of employment abroad. And you can get it to be opening a new business in the US. So the first question on this was the L1A versus the cap exempt H1B, which has better chances of approval at the petition and consular stages. It's interesting. I'm going to assume this person's from India. And I think the answer is different if you're in India versus like if you're in Italy or something. I think that an H1B is easier if you're in India, but an L1 or an H1B would be equally easy if you're in Europe. And that's simply because for India, there's more scrutiny on L1 transfers because of consulting firms like IT consulting firms that transfer a lot of people here. So those visas have the potential to get slowed down, especially if it's for a new company or a company with a small number of employees. So I think it depends which country you're from, how established your company is. Is it a startup or is it some other type of company? Can you get a change of status or do you need a visa stamp with consular processing? What's your end game? Are you trying to get a green card in parallel? There's a lot of factors. So that would be something where I would just love to have a one-on-one consultation with you. And we'll share that information at the end. But Rebecca, thank you so much for putting the podcast link with Sanjay in the chat window. That's where to think about like the right order of operations to protect your IP for your future startup if you're currently employed at a big company on an H-1B. But I think the other thing that would be helpful to share is our landing page for folks to put in their name and email address and type of question that they have, which is the first step to booking a consultation with us and getting our questionnaire. Okay, so that's the L visa. There's a few more L questions that I'll try to answer now. How are we doing on time? Oh, this is good. Got about halfway. Okay, I'll try to speed it up and get to green card shortly because I know that's another topic of interest. If you had an L1B, oh, thank you so much, Rebecca. There's our contact page. If you had an L1B visa as a software engineer, can you use that as evidence for an O1 or EB1A? Maybe. The L1B requires specialized knowledge. And there's probably an argument there that you had a leading or critical role at a distinguished organization, which is one of the factors for extraordinary ability. I don't know that the L1B in and of itself would be sufficient evidence, but probably you had a role that would qualify if it made financial sense for your company to sponsor you for that. The other thing I've seen is some people were able to get the national interest exception to travel to the US during COVID. I think that would be more compelling evidence of like a former immigration status being related to a leading and critical role. But certainly, bring up your L1B to your attorney and mention that, and maybe there's a way they can tie it together. Okay, what documents should the sponsoring L1A employer submit periodically to the Department of State or U.S. Citizenship and Immigration Service after the employee starts working? There isn't. The way all these visas work with the petition concept is that you're petitioning for a period of future employment. So you're getting like pre-clearance for somebody to work for you for the initial 1 year for a new business, or 3 years for the initial L1, or 2 years on an L1 extension. Sometimes you have to notify USCIS if the employment is ending, like in an H-1B, but there aren't just like random compliance updates you have to do. It all happens at the original petition and at the extension stages. Okay. Okay, H-1Bs, you probably all know that there's a lottery. The critical thing I want to mention here is this concept of AC-21 extensions beyond 6 years. If you've gotten your H-1B since like 2020 and because of COVID and tech layoffs, you do not have a priority date yet because your employer canceled their perm program, or you changed jobs and you never got like perm restarted at the new company. You need a priority date that has to do with green cards. But the reason I'm pointing this out now is because once you have an approved I-140 petition, you can get unlimited 3-year extensions of your H-1B beyond the 6 years. And if you are married or get married, your spouse can qualify for an H-4 work permit. So if you're on H-1B and you don't have a priority date yet, your one thing from this webinar might be to initiate a self-petition EB-1A or EB-2 NIW green card petition for extraordinary ability for national interest. And that's going to be the next section on green cards, but I raise it now to tie it into these unlimited H-1B extensions that are really, really important to secure, especially now that companies are ending their perm programs. H-1B transfers, once you have an H-1B, you can transfer it to another company. What's my next slide? We've had a lot of success on this recently. There's 2 things we're doing right now for a lot of bootstrapping AI startup founders. One is, okay, let's say you work at a travel company and you want to create a pet food AI assistant. So like you've established and you're using your personal laptop to tinker with these concepts outside of work hours on your personal Wi-Fi. So you feel very confident that there's no intellectual property issues with your current employer. We are getting H-1B, concurrent H-1Bs approved for aspiring startup founders to be the CEO and even 100% owner of their new baby tech startup company that they just formed to legally work there for 10 to 15 hours a week to be able to actually build the product, get customers, make money, and establish the traction they need to raise pre-seed funding. So that's a very significant thing that's important for AI and other types of founders right now to be aware of, is you don't have to fully quit your job and go all in on your company. And with the funding market the way it is right now, the way to legally get traction is to get a part-time concurrent H-1B, and we can do that. It's an option. Now, there's another type of concurrent H-1B that I talk about, which is for cap exemption. And this is helpful for people who did not get selected in the lottery and they need a way to stay here. There's a couple of programs doing this on the market right now. But essentially you get one H-1B, like maybe part-time to work at some sort of nonprofit affiliated with a university, or a university as a teacher, or a research job or something. And that organization sponsors you for the first H-1B. And then a private company that normally would have to put you through the lottery can sponsor you for a second concurrent cap exempt H-1B with no lottery. So as long as you're maintaining the part-time employment at that cap exempt organization, your other employment, which could be full-time at the private employer, might not have to go through the lottery. Okay, so now let's talk about green cards, because we have a lot of green card questions. EB-1A, EB-2NIW, efficient paths, grace periods and timing, fast track. Okay. I think I said the word fast track your green card. What does this mean practically? Is it different to premium processing? Yes. It is different from premium processing because premium processing is a government program that you can pay for to get a decision on the thing that you filed, usually in 15 to 45 days, depending on the rules for that particular thing you're requesting. Fast track green card is a phrase I invented to talk about how to get a green card fast, which is the point of this section. So there are many paths up the green card mountain. You can marry an American or do the 90-day fiance thing. There's a lottery for countries with low levels of immigration called the diversity green card lottery that happens every year that's free. But if you don't want to have to get married and you don't have $1 million and you don't want to be in some random lottery and you don't have a company that's going to sponsor you, the question becomes, how do you get a green card as quickly as possible by yourself based on your merits, your professional accomplishments, your achievements, rather than money, marriage, or randomness? So that's where we look at the employment-based green card categories. EB stands for employment-based, 1, 2, 3, 4, 5. EB5 is the investor version. Companies typically do EB2 and EB3, and they did it with perm. But as we've seen, I think from Google and might have been Apple, but there are several perm programs that are being put on pause because with layoffs, they just can't get people through perm successfully right now. So the types of green cards that do not involve perm, which is where you have to find an American replacement for you, but if you're an EB-1A, EB-1B, EB-1C, or EB-2 NIW, there's no perm involved. And if you're doing EB-1A or EB-2 NIW, you can also self-petition. So those are the two most popular green card pathways for my clients. And the easiest one to get a priority date, like if you just graduated from your master's degree and you're working at a big company and they're not able to do your perm right now, that's really, and you're not extraordinary ability yet. Even if you're from India or China, where there's a long wait for EB2, just getting started with your EB2 soon is critically important. And the sooner you do it, it could like save you longer and longer times because there's a finite number of green cards every year, but there's a growing demand. So taking steps sooner could save you outsized time on the back end, depending on when you start. So today we're going to be talking about EB-1A and EB-2 NIW primarily, and those can be self-petitioned or petitioned by an employer. But the benefit of self-petitioning is you just have to commit to working in your field in the future, and you're allowed to change employers. But if an employer sponsors you for an EB-1A or EB-2 NIW, it's nice, but you still have to be working for them when your I-485 is filed. And the purpose of the green card is to allow you to continue working for them in a permanent offer of employment after you get your green card, usually for like 1 to 2 years. So a lot of my clients prefer to self-petition so that if something happens to their job or their startup, as long as they keep doing what they love in their field, they're still allowed, they still got that green card in good faith, and it's clear that they can proceed. Okay. So the very first question we got was from somebody who got an O1. Having successfully been approved in the O1A category, what are the typical things I should consider when applying for the EB-1A that are different but can have a significant impact on potential success? It's an excellent question. I don't think you have to do different stuff, but having more stuff or changed stuff would be helpful. Congratulations on getting your O1 approved. There is actually clear guidance in the USCIS policy manual that states that deference is to be given to prior approvals of O1 status. So therefore it's, it's great. You have an advantage in getting your EB1 because you've already been approved as a person of extraordinary ability in the past. So they like that. You have a higher chance of getting your EB1A approved than if you had gone straight from like H1B to EB1A. That being said, as I mentioned before, there's just some people who can't do that. So that's okay too. They can still get EB1As. But this is such a personal question. I mean, in general, I'm going to go back to my slide here. Like, I don't know who you are, what your field is, what your job is, what you did before, what you've done since your O1 was filed that you didn't get to include, what you've done since your EB1 was approved that, nobody knows about yet in immigration. So I would just go back to these O1 requirements. There's a slightly different list for EB1A, which involves additional things for artists. But you should just be tracking the same types of evidence. And this would be very appropriate for a consultation with us. We'd love to help you. And we can take a look at what you've done, with up to the O1A and then after the O1A, and give you a sense of if you actually need to do more or not, because some people who got an O1 are already qualified for an EB1 and nothing else is required. So that's something to keep in mind. Okay, here's another green card question. If you have a company sponsoring your EB2 or EB3, can you work for another company when your EAD arrives? Technically, yes, you can. The EAD based on an I-485 is for unlimited employment, including self-employment and other employers. However, I would be careful about your intellectual property. You can refer back to that Sanjay IP podcast in the chat window. I would also be careful about the dates and what's going to happen to your main employer after your green card gets approved. If your I-485 is approved based on the EB2 or 3 for the primary company, then you're supposed to keep working there after your I-485 is approved. So like, yes, you could continue the other employment that you have. But if you want to switch completely during the I-485 process, that's called an I-485J, and you have to wait at least 180 days after your I-485 has been filed to be eligible for that. And it has to be for a same or similar occupation at another company. So if you don't like your job that's sponsoring you for the green card, maybe take a step back now and make sure that that's still the best, ultimate path for your green card while there's still time to pivot or start an additional process if necessary to help you preserve the optionality that you need in the future. Okay. The most efficient path for Canadian citizens to get a green card. So we talked about these different categories and how the EB1A and EB2 NIW can be self-petitioned. We talked about how the EB1A is similar to the O1A, but just like more essentially. The other category that I really like is the EB2 National Interest Waiver Green Card. And this can also be self-petitioned. It's an EB2, not EB1 category green card, which means that there are more backlogs in the processing time. And it used to be that only people from China and India had these backlogs, but now everybody in the world has backlogs in the EB2 NIW category. So even if you were born in Canada, you now have a wait time. If this is your first time you've ever filed an I-140 for yourself by either you or a company, and you're getting your very first priority date, I would estimate that you might have to wait about 18 months to be at the front of the line from whenever your priority date is happening, and your priority date is the date you file You file your I-140, assuming that it's eventually approved. So this is not the fastest for Canadians anymore. All in all, it might take 2.5 years to get through the process, but it is the easiest self-petition green card. Your other option is the EB-1A. And for somebody subject to the Canada line right now, the EB-1A is current, which means that you could theoretically file your I-140 petition and your I-485 application at the same time. But for, practically speaking, most of my clients who have a current priority date typically get the EB-1A or EB-2 NIW I-140 approved as step one. And then once it's approved, they immediately file their I-485 if the visa bulletin is current. And then the one other thing to note on visa bulletin stuff is, let's say you were born in China, you moved to Canada, you're now a citizen of Canada, and you married somebody born in Canada. Well, magically, you could be in the Canada line now, not the China line, even though you were born in China. But it's not because you're a Canadian citizen, it's because you married somebody born in Canada. So you have to go in the line of your country of birth, not your country of citizenship. But there's a thing called cross-chargeability if you're married to somebody else born in another country. So country of birth for green card. So for Chinese national filing the EB-2 NIW, how long do we expect it will take to have it approved? I don't know. Part of this depends on the election, but I think it could take I actually have no idea. It might take like 5 years. It could take more. I'm not sure. I don't know. And I that's an estimate. I have not looked at the visa bulletin on that to make an estimate lately, so I do not know for sure. But it will be several years. Is it better to file the I-140 and the I-485 together, or it doesn't matter too much? I mean, if you have $100 million from selling your tech company and you don't care about losing a few $1,000s here and there, and you just want your green card as soon as possible, file them together. But if your I-140 is denied, the risk is that you would lose the money you've spent for the lawyer and the USCIS filing fees for the I-485, which is why some people prefer to wait. But if you just want to get your green card, you are welcome to file it all together at the same time if your priority date is current. Okay, a few more green card questions, and we have about 6 minutes, so I'll be wrapping up here. So, reach out to us. We have a couple things that I'm offering. One is our online class called Alcorn Academy, which is a self-paced class to go through ideas to help you brainstorm how to improve your credentials for O1A, EB1A, and EB2 NIW. I recorded all the webinars. There's about 15 videos. I also have like PowerPoints in there of actual requests for evidence screenshots where I explain why the request for evidence happened and how to get the types of evidence that would avoid a request for evidence. So a lot of people have gone through that class and have qualified for O1A and EB1A and EB2 NIW. I also have a live version that the next cohort is going to be starting in August. We're on the second cohort now. And that's kind of like sessions like today, where we work together in a small group for 8 weeks. You have access to all of the modules, plus I answer any questions you have, and we make individual plans each week for which organizations to join, which articles to publish, where to get media attention, what things to judge. And so that's like a very live and interactive thing, just depending on the needs of the people in the class. So you're welcome to sign up now for the next 8-week cohort that will start later this summer. If you do have evidence already and you need help figuring out if it's enough before you file, we do offer Legal Launch. That's a $2,500 program. It takes 4 weeks. We give you our checklist. You upload your evidence. We do our 3-stage internal review, and we let you know, hey, you don't qualify yet, but here's your personal checklist that we made exactly for you to let you know what we think you should do so that we would feel comfortable that you have a winning case. Or, hey, you're qualified. Let's just get started on your next step now. We'll fully credit the $2,500 directly to your O1A, EB1A, or EB2 NIW, depending on what you want. The first step for a lot of this, if you don't know what you want, is simply to go to the chat window and fill out our contact us landing page that Rebecca provided. And once you give us your initial contact information, we'll be emailing you our consultation questionnaire in which you will see a form like this. We tried to make it as simple as possible, but you just check everything that applies to you. Okay, so I am going to actually try to answer as many questions rapid fire as I can. I wrote a book. It's a bestseller. It's on Amazon. I recorded an audiobook. You can buy that on Audible and Amazon. It's a choose your own adventure, and there's a lot of charts and graphs for how to navigate US immigration in different creative ways. And I also have a podcast, the Sophie Alcorn podcast, which is available on Apple Podcasts and Spotify and whatever else there is for podcasts, but subscribe to that too. That's every week. Tell a friend. Okay. As a new grad in software engineering and AI, is an employment-based visa the best option for me? Yes, you should do what you can to try to get an O1 and an EB2 NIW completed as quickly as possible. That will help you avoid STEM OPT and finding a job and the H-1B lottery, and then you can always upgrade to an EB-1A later. What are the immigration changes you are expecting with the elections happening? From Trump's immigration policy, it seems like H-1Bs would be dropped, but do we expect any positive news for software engineers? All of my clients are doing amazing things that are shaping the future of humanity. So I think you're still going to be prioritized in any sort of administration changed. The biggest impact that I see now practically that I've been talking about on my podcast is visa processing abroad might slow down at the embassies and consulates. So if you know you need to renew a visa in your passport now, it's better to do your stamping before the election than after the election. If Trump becomes the president, I will probably go back to recommending reduced international travel until you have a green card. But they can't just like drop H-1Bs. There are legal processes that they would have to go through. They might restrict them more or something, but we're happy to help you navigate any changes. If a person is not able to file an O1 during the H-1B grace period, could they transfer the H-1B to B1 or B2, stay in the US and do the activities to meet 3 of the 10 criteria and file the O1 or O2 during this 6 months? Absolutely. I've been advocating that since their initial tech layoffs in fall of 2022. It works. Now they will let you online file a change of status to B1, B2 yourself. And if you know you want to get an O1, I would recommend a B1 instead of a B2, because a B1, you can do business owner activities. And there are lots of ways to get the O1 criteria accomplished without unauthorized work. And I have a lot of TechCrunch articles posted on alcorn.law on how to do that. If you just search for O1 on alcorn.law, you're going to find like 100 articles at least. What if your advanced degree is not in software engineer, but you work as a software engineer? Can you still petition for the EB1 and IW? Yeah, the EB2 and IW. You do not necessarily need a degree for the EB2 and IW. You can do it based on exceptional ability, which is easier than an O1. So you should contact us for a consultation. Last question. So if you found a company using the Delaware C Corp, would the best visa for the founder to move to the US be an L1? Would that be the quickest? If you qualify, maybe, probably that or an O1 is what most of my international founders use, but we should figure that out for you in a consultation. All right. Well, thank you so much, everybody. I really appreciate all of your engagement. Thank you so much. Have a wonderful day. And always feel free to reach out to us if there's anything we can do to support you. Please feel free to share the recording with a friend when you get it. And thank you so much. I look forward to meeting you all personally one day. Have a great day. Bye.